So we're going to talk about patenting artificial intelligence today. Everybody sees the screen, right? All right. So we're going to talk a little bit about artificial intelligence, some of the concepts about the technology, the basics, the very basics about artificial intelligence, some of the issues in the AI world, and then we'll talk about some best practices for drafting applications, prosecution, and then provide some examples of some cases that I have filed. So artificial intelligence is the use of machines to mimic cognitive functions associated with humans, such as learning and problem solving. This is like the old definition of artificial intelligence. Basically, is trying to emulate what a human does. But I think that definition today is a little short because there's things that machines are doing now that humans cannot. So to me, artificial intelligence is any intelligence but a non-being. And I think that's more where we're going today, and we'll see some cases why that is the case. So typical artificial intelligence can be anything, any algorithm that allows somebody to emulate intelligence. And today the hot topic is machine learning. We'll discuss that. But it can also be some algorithms, some decision trees, some rule-based systems. You can use the statistical probabilities, economics, anything that allows you to emulate intelligence. And typically, well, machine learning relies on large computing resources and mining big data sets. So the U.S. Department of Treasury, says that by 2030, AI technologies could increase North American gross domestic product by 3.7 trillion and global GDP in 15.7 trillion. This is before the coronavirus, so I don't know if it's up to date, but anyway, AI is growing, as everybody knows. So why is AI so exploding these days? And there's several factors that come together to allow this the development. One is the explosion of computing power, cheap computing power. Everybody has computers that are more and more powerful. There's also explosion of data. There's the internet. Everybody's capturing a lot of data, and that data is available. There's also even more cheap on-demand computing on cloud services. And then finally, there's the development of machine learning algorithms that keep getting better and better to be able to find correlations within the data to make inferences. So the applications are almost in everything today that you can think of. Is some people are doing artificial intelligence, legal search, regular search, job search, internet search, or robots, or self-driving cars, intelligent assistant with the language assisted, the bots, health diagnosis, patent drafting, not very good yet, fortunately, but people are doing efforts to do patent drafting with artificial intelligence, marketing, customer service, image recognition, fraud detection, speech, communications, etc. This is an example of, as a few months ago, that a new artificial intelligence model developed by MIT Computer Science Department analyzed mammograms and predict breast cancer risk up to 5 years in advance. So even better than humans, they can analyze images looking for breast cancer. This is just one of the applications. Now let's talk a little bit about AI and the law. And AI intelligence law is the field of law dealing with the rights and liability that arise from the use of AI. And as anytime there's a new technology, especially disruptive technology, there can be some issues arising from that. The USPTO issued a revised guidance on patent eligibility subject matter on 2019. This is mostly about the 101 exception, but the emphasis there is practical application. And I think it's one of the things that we have to keep in mind when drafting AI patent applications. On August 2019 of last year, the USPTO requested comments from people to see if AI would require changes in the way the USPTO operate. And different people submitted different answers. Our belief in our firm is that the laws that we have are very valid for AI as long as we're using the same thing. It has to be new, novel, non-obvious, and everything. And I don't think there's anything in AI that makes it that we need to change the law. The EPO also, the European Patent Office, issued guidance on AI ML examination 2018, It's pretty much like everything else, technical effect, technical solution, that's what the EPO use it. And they have determined that the machine learning models are abstract. It's a little bit, I don't know, I don't agree with that. Also the EPO, as the US, is very strict with mathematics, but they don't allow mathematics, which I think is wrong, but that's a little bit of a side things. So now, oops, sorry, let's go back. Moral issues. The issues in artificial intelligence law rises like, what happens if I get hurt by a machine? You know, if I'm in a car and then they fall in the wrong place, or if I have a robot in the airport, you know, those that walk around that come and hit me and break my toe. So what are the product liability laws? Who's liable for the damage hurt by the machine? The people that build the machine, the people that build the algorithms, the people that put it on near you. There's also fairness. Fairness is a very important concept in machine learning. Like, for example, if you develop an algorithm to assist you in hiring, you know, for employment to find the best candidates, but all of a sudden, you know, the algorithm analyzes the data and somehow it determines that candidates for certain neighborhoods happen to be more affluent neighborhoods, tend to be or happen to be have better curriculums or are better workers. Then the machine learning, you know, doesn't have the social concept. So they're just going to assume that candidates from those neighborhoods are going to be better employees. And this is what there's laws coming in, how to reduce bias or eliminate bias from these kind of decisions. And this, you know, this includes like things like deleting data. Some data has to be deleted from the profile of the system or not considered to be able to make sure that the algorithms are fair. There's also issues of privacy, and I have a client that I'm working on very, I mean, hot debate about how to use privacy, how to do law. This client has a lot of data, but they don't know if they can use the data because of privacy concerns, even though they would like to. So maybe there's the idea of eliminating making the data anonymous or something so they can at least use a subset of that. Anyway, and the regulations that some places, I think like New York, already have regulations on how to use automatic decision system. Some examples is that this is the monkey, the famous monkey that took a selfie, and you might have seen the picture, but there was a copyright issue. There was a fight for the use of the picture between the photographer and PETA. And PETA filed a lawsuit on behalf of the monkey to the copyright ownership. And anyway, in the end, the judge says that the PETA didn't have a standing because they were not related to the issue. They also said that human authorship is required today. So if the animal took the picture, there's no copyright. EP applications, I don't know what I meant with that, but anyway, training data ownership. And the question is, if you use a machine learning and you use the data from somebody else, you know, how does it affect the AI? Especially people that have training sets. You know, there's people that go out there and go through a lot of effort to get a comprehensive training set. But training set per se is not patentable, right? You know, maybe you do a copyright or something or a trade secret. But if you let somebody else use it, you know, how do you protect your training set? Or if you train a model with that training set, how do you get, you know, protection also from the model, etc.? So there's issues there. Use AIs is starting to be used for legal purposes, assisting patent attorneys. We see some tools that are out there that are trying to do analyzing. Today, I think the tools that I use, well, I use one tool, but the tools that we use are typically do analysis, like on a patent application, find correlation, make sure, you know, the grammar is right, the numbers are right, the things are in place. But there's people who are talking about getting a claim set, giving an AI program, and then he'll write a patent application for you. So maybe that's the future. I don't know if we're there yet, but it's going to be interesting when we get there. There's also what happens if you get a bot giving legal advice to people. Is that unauthorized practice of law? So we have to be careful with that. And you know, how do you identify novelty when something is invented by a machine? And I have a couple of examples that have been in the news recently. And my opinion is it'll probably follow a similar path to software patents. You know, software is patentable, but must have technical novelty beyond implementing something already known on a computer. Just because you have a known process, just put it on a computer, is no novelty. So Same thing is going to be similar with AI. Okay, so this is in the news. Last month, the USPTO published a decision on this application by a Mr. Dabus. I don't know that's how you say it, but the last name, Invention Generated by Artificial Intelligence. And the title was Devices and Methods for Attracting Enhanced Attention. This is the inventor. Dabus stands for Device for Autonomous Bootstrapping of Unified Sentience, a swarm of many disconnected neural nets. So anyway, this is a group of people from the University of Surrey, I think in England, and they filed in the US, they also filed in Europe. So the PTO in the decision, because there was a petition saying that the inventor should be allowed to prosecute this patent application, but the USPTO look at the code and look at different sections and pull out sentences that show how the code points to people as inventors. For example, the term inventor means the individual. Then also the terms joint inventor and co-inventor mean any one of the individuals who invented a patent application. Section 101, whoever inventor discovered, then each individual who is the inventor shall execute an oath or declaration, any person making a statement required under this section, etc. So the code was written with the point of view of a person. So that's the idea. So anyway, this patent application, we couldn't see it in the US because it hasn't been published, but there were two applications also the same group filed in Europe, and they were published. And this happened in January. They were also, Europe denied them then. The first one is a food container. It's some kind of protection for packaging, and as you can see, there's some kind of fractals or something. And they use a machine learning model to develop the patent, this food container. And then the other one is these devices and methods for attracting enhanced attention. This is the same as in the US. It talks about in rescue scenarios, and without getting all of details, but it talks about how to use the right frequency and the right lies to attract human attention. I was just glancing through it and looks at the conditions. There can be noisy environments. How do you make the best use of this light to attract human attention? So anyway, both EP and the US say no can do. And this is the question, again, when I'm giving this presentation before, people argue, is AI patenting worthless? Because some people are a little skeptical, using known tools. Many data scientists, you talk to them and say, we're just using known tools and we're doing this in applications, so I don't think there's anything patentable there. But it's not so fast, there might be something there. Other point is it's difficult to detect infringement. Like if we're in our lab and you run a model, we do the testing and then we use it to do something. Many times, like we don't know what's behind the scenes. So how can I detect an infringer, even if I find a patent, if I obtain a patent? And some people say, hey, these are abstract concepts, a lot of these things. So under 101, we're not going to be able to pass. But that is not true because we're seeing a lot of machine learning patents allowed these days. So my thought on this, and if anybody wants to add after this, I'll be happy to hear. But it's, there are benefits also to file a patent application. First, you can protect your technology. Use something that is new or novel. Right now, everybody's running their fields to start doing, the particular application where they haven't used artificial intelligence before, but now they have data, they have methods. Then everybody's running or to get those models going. So you can protect the technology because, if you try to keep it as a secret, secrets walk out the door with your data scientists, or somebody publishes a paper or whatever, so it's easy share. At least you get some kind of protection. Also, being the first to protect in an industry will provide you that competitive advantage. At least you say to the people, hey, this is what we're doing, and litigation might be difficult, but it gives you that edge. And if you don't file, maybe your competition will. And then they're going to come and do, send you a letter saying, cease or desist, and don't use this part of the technology because we have these patents. And then you're going to have to go through like expensive litigation. And I think in this case, it's better to have the sword. You'll be the one holding the patent application than trying to look for excuses that why you can use that technology. And finally, the abstraction rejection can be overcome with technical details and so on, practical applications. So that we've learned with all these years after Alice how to get these patents applications allowed. So anyway, I don't know if anybody has any comments on this. No, all right. Okay. So moving along, I had a lot of images about AI, how it's growing, a lot of applications, etc. I look for today for some recent data from March. This is AI patterns by geography, and this is published by the Statistical Research Department. This is AI patterns, so these are issue patterns. So it looks like the US has a great lead. China, Europe, Japan, Germany are behind. So a lot of patents on AI. This is something from last year, but this is patents, I think it was patents filed by geography. And in this chart, so China is like, it's filing like crazy. I think it was 2018. And part of this is China has had some incentive programs to people that file patent applications. They're given monies and incentives, so everybody's filing everything. So that's a little bit of a skewed bias. But anyway, China is paying attention to AI, so is US and other geographies. So we're going to talk, my presentation is patenting AI, but basically we're going to talk about machine learning because the hot field today for AI is machine learning. So let's talk about machine learning. So machine learning gives computers the ability to learn without being explicitly programmed. Our old paradigm is you get, you have an idea, you want something, you program it, and then you can put inputs and get outputs. Here, machine learning is you give it a bunch of data, you do a little bit of analysis, explain how the data is prepared, we go through that. Then a machine learning algorithms prepare a model, and that model is the one that takes inputs and produces outputs. So it is not explicitly programming. So machine learning explores the study and construction of algorithms that can learn from and make predictions of data. Such algorithms overcome following strictly static programming structures by making data-driven predictions or decisions through building a model from sample inputs. So example applications include email filtering, detection of network intruders, optical character recognition, computer vision, and many more, language detection, etc. So let's talk about regression. So understanding now the very basic of machine learning is a typical regression analysis. And this might you remember for high school or algebra. You have XY, you have some results from an experiment, you have inputs and a variable, right? And you have these dots. And what you want to do is find a line that, hey, this is the trend. So you want to find the line that meets that trend. And then you have those, sum of the squares different with the line and stuff like that. So there's some mathematics that give you that line. So later on, if you get a new input X1, you can predict what the output would be based on that line. So that's the simple regression analysis for one variable. So how does this translate to machine learning? In machine learning, these dots, all these values that you have, is the training set. The line that you find is the model, because that model is what is able to take in an input, give you our predictions. And we call, in machine learning, we call features as the name of the variable. This is one variable. So what it gets interesting and complicated is when you have 100, 200, or many features, and when you have many different points. So this two-dimensional model becomes a hyper-dimensional model, and then you have a lot of dimensions, then you don't lose the visions, and that's where the math comes into play to make those separations, right? Another typical use of machine learning is classification. And imagine you have two features here, feature one, feature two, whatever is, the shape of the face, the shape of the whiskers, the legs, whatever. But you found two features that you think it differentiates cats and dogs. Then you plot those on a chart, and then you have the cats over here, and you have the dogs over here. The goal is to find a line that separates in that space the dogs from the cats. And this is what's called the trained classifier. Because when we get new points, the points that are on top and to the right of the line, is the cats, and on the bottom is the dogs. So this is the space separation. Again, when it gets to multiple dimensions, then it gets much more complicated. So again, summary of regression models. This is the one I was telling you about. A regression model is when the output variable is a real or continuous value, such as a salary or a weight. This example here shows that it could be a curve. It doesn't necessarily have to be a line. It doesn't have to be a straight curve. A curve can go up and down. It could be polynomial. So part of the algorithms is the machine learning algorithms try many things to find all those curves. You know, sometimes it's not overall brains. Sometimes it's brute force trying many, many things until you find the right line algorithm, right? So there's not a lot of intelligence sometimes. It's just brute force. Then there's neural networks. Neural networks are widely applied today more and more. And basically, they call neural network because it's trying to emulate the human brain. And what you have is you have different layers in which each layer performs a calculation or some value and then gives some inputs to the next layer. There's also coefficients into these lanes connected here. And at the end, you get an output. So those are neural networks. When you have hidden layers, you know, there's usually the input layer, the output layer, they're called deep networks. And you hear that deep neural networks and deep learning. All the use algorithms is dimensionality reduction. Machine learning typically works on vectors. So when you have your data, you know, like there's somebody's name or skills or whatever, you eventually capture all those features and you put them on a vector. Sometimes you can concatenate all those features and then you get a vector. And sometimes those vectors can be 200, 300, 1,000, very long. But, you know, machine learning likes, you know, a smaller vector, you know, maybe 100, maybe 200 dimensional. If it's too small, then might be not helpful. But there's algorithms to reduce your initial data set, long vectors, to a small vector. And then you can use that with your models when you're training. There's two high-level types of machine learning. One is supervised learning, and that is where I give you data, and then this is an example. So I give you, like, imagine all those data. These are features, and I say these are the feature values 5, 7, 24, and these are dogs, and these are cats. So basically, you tell the model this is your sample. And then I'll say, okay, I found the correlations, and now you give me new inputs, and I'll tell you what is a cat or where is a dog, like a classifier. And supervised learning sometimes is like, there's no label, well, I'm gonna read, no labels are given to the learning algorithm, leaving it on its own to find a structure in its input. And supervised learning can be a goal in itself, discovering hidden patterns in data or a means towards an end, feature learning. So basically, sometimes you just have a bunch of data and you don't know what's going on and you don't have the luxury of knowing a previous data training set. So you use unsupervised learning. In my experience, most of the learning is supervised, because it makes more sense to say this is an example of what works, and then you can make inferences than trying to find hidden patterns, and much more complicated. Another form of machine learning is called reinforcement learning. Some of the models we saw before, they're kind of static. You know, you get your data, you train your model, and from now on you use your model inputs, output, input, output. Reinforcement learning adds the state in which you're in to the learning, and it's kind of smart because as your system evolves, you know, maybe you're a car, you're driving, then some of the variables in where you've been before also helps you to determine the prediction. So this is called reinforcement learning, and there's a feedback mechanism. Okay, so this is a typical chart I put in my patent application, and basically we discussed before, we have the features, and the features is like, we'll see some examples, but it could be the color, let's say, do image recognition, could be the shape, the color, the lines, the vertices, you know, some things that you identify, things that you believe are going to give you values, because sometimes you can have features that do not add to the classification, and the more features that are not valuable, the more complex things are. So part of the value of the data scientist is to find out the features that can give you those correlations, right? So when you get that features and then you get your training data, then you put the training data, you know, associated with those values with the features, create those vectors as I was telling you about, and then you use the machine learning, the training, and you know, it's called also the feature appraisal. This here is all those algorithms, the neural networks, the regression systems. Anyway, there's a bunch of them. So that is the algorithms. They take the training data, understand the value of the features, and then they produce a model. And the model is what you use when you get new data. You make an assessment, right? So it's always good to put this in a patent application because, I have the boilerplate. When you sometimes, I have cases inherited from other people that talk about machine learning. They don't give much of an explanation. The examiner comes and puts like, oh, here's a decision tree, here's a heuristic, he said, this is also machine learning. And then you try to explain what machine learning is by quoting Wikipedia that, based on amount of data, you're halfway lost. So you better have something in your spec to differentiate your machine learning models from other types of algorithms. And sometimes to differentiate your machine learning process to other ones. Maybe somebody else is doing image recognition, but not all image recognition is the same. So that's why you need the details. Again, this is a little summary of what we're talking about. You get the training data, you get the features vector, create the algorithm, or run it by the algorithm, and create the model. Okay, here's a question, see if you're paying attention. All right, here's a scenario. Party A, Inventor or somebody, develops an algorithm. There's a bigger guy, develops a great neural network to do, let's say, image recognition or something else. B is a guy that gets the training data. Then C knows about A and B and trains an algorithm to get a model with that training data. Then somebody else, D, runs the model and the model generates an output. And then E realizes, oh, this output is a process machine manufacturer composition of matter that is new or useful. Like the guys from England, right? So who can get a patent? Anyway, anybody wants to give a guess? You don't have to, it's okay. Go ahead, Jonah. Just a minute.
I believe E, because they discovered the result.
Oh, boy. Anybody else?
I think it's A, because they actually conceived of the algorithm.
Okay, that's good. All right. Funny, my original answer was like, well, almost everybody except E, Jonah, sorry. but let me explain, right? It all depends, right? It all depends. So A develops an algorithm. If the algorithm is complex enough and you show that it has a practical application, this is like new math and new cost function and stuff like that. So that could be technical novelty there. So, that is right. A could get a patent application in certain cases. B gets the training data. Well, you just go to a database and get the training data now, but sometimes getting the training data is difficult. Sometimes you have to go processes. Sometimes you get some of those, sometimes you combine databases. So maybe getting the training data, it's also patentable. But sometimes not, but sometimes could be. C trains the algorithm to get a model. If C just runs a typical algorithm and just training, maybe not. But sometimes there's tricks to either accelerate the training. We'll see, okay, if we have time at the end, where you adjust the training by combining the training with some other training or some other parameters that you know. So there could be also some complex technology on how you do the training. So C could get a patent, could, maybe not. D runs the model and the model generates an output. D was got a hard time, just running the model is not very creative. But sometimes, the thing here is sometimes you run the model with something else. Maybe you put in a different scenario, maybe you run two models. So just run the model by itself is not, but maybe you can put it together in a whole solution where you could get a patent. But just running the model, probably not. And then realize that the output is a process machine, just realize it's like discoveries these days. The patent, the SCOTUS doesn't give much credit to that, and yeah, I don't think so, Jonah. You want to comment on that, or I don't know? I don't see it.
Well, so my comment on that is the U.S. Constitution says it will guarantee rights for inventors rights to their discoveries, and 101 says grant to inventors and artists, or I guess. I agree. There was a great article somebody wrote about discoveries. But the Supreme Court has said discoveries are not, this is all these drug manufacturers. I do software, but all these people that go out there and like right now people are looking for cures for coronavirus or whatever. And the Supreme Court says, no, if it's in nature, it's not. So discovery is a tricky word. I agree with you. Yeah. In the chat window, there was also another vote for D and another vote for A. Okay.
Can I make a comment on D?
Please.
I think D and A are the same person, and D provides the structure that A needs.
Well, they don't have to be the same person. I mean,
Well, no, because I mean, an algorithm's an algorithm, but D has the structure for that algorithm, right? Like a processor, memory, and all those things. So adding structure for section 120.
yeah. Well, yeah, I think what you're saying is a little bit part of the training process. I mean, they're intrinsic. I mean, I think you're saying you're providing the structure because you're getting a training set with that structure for the algorithm. So I think you're kind of, yeah, in the same direction. Okay, all right, let's move on. We have more stuff.
I'll make one more comment, which I think that often in my company, as an example, we do step A through E all within one company.
Yeah.
But I guess my question to Gustavo would be, if they were theoretically separate people, then who gets the patent? I think your answer was D.
Yeah, if they were theoretically different, yeah.
Yeah. Again, this is very high level. It holds, the devil is in the details sometimes. You know, it's like, where is the technical complexity? Okay, but you can see these are issues that come up, and it's issues we're trying to solve around machine learning. Okay, so I know some of you have experience. I presented this to Santa Clara students a couple of weeks ago, but anyway, some of you don't have the expertise and wants to become a patent drafter. This is some of the advices. You know, take a class or read a book. I bought a book in Amazon called Machine Learning for Dummies, and it was surprisingly good. If you just want to get started on learning that, I mean, it has these concepts I'm telling you about, regression analysis, and it also gives you some tools if you want to start doing actually some machine learning. I didn't get to that part because I don't practice that, but just to get familiar with the concept is a good read. Also reading what other people do, you know, reading how some people write their cases, use the boilerplate, put all the technology around it, you know, look at the claims could be very helpful. Of course, working with a mentor here is very helpful, as in, you know, anything related to patents, really, especially when you're starting. Also here, as I say, be fearless. Know how to work with data scientists. You are not a data scientist, so work with them on getting all the details. Sometimes, you know, probably happens to all of you with some experience. You go to a meeting, a guy there is a very techie, he's telling you a bunch of stuff. Some of it is going over your head, and you hope you capture it on the recording and you understand later. Sometimes you ask questions. But, you know, what I learn is like, I'm trying to ask as many questions as I can. I'm trying to understand as much as I can there. And, you know, the data scientists give you this cost function and give you a bunch of parameters. So I'm pasting and say, you know, what does it mean? What is that? What is that? So, well, everybody knows that it's through standard deviation. Okay, you know. So sometimes you have to look like a fool. So when you write the patent application, you have all the details to write a good patent application. So don't be fearless. Don't get intimidated. You have to ask the questions. Also, you know, preparation ahead of time is always helpful, but you have to do that. Okay, then find a good boilerplate or make one, you know, with good definitions so you can help in prosecution. Okay, so you're drafting an AI patent now. What is the content? For clear description, you know, as usually, make sure you define all your terms, especially the ones on the claims. Identify the problem being solved. Data scientists, many times they'll tell you, well, this can really work for anything, you know, like you could search anything. So, but it's like, okay, well, tell me one application where this works, because you're going to have to use that application when you draft a claim, or at least in the patent specification. Don't make it all just about math or abstractions. Identify the technical novel aspects, like everything. Make sure you understand where the novelty is and provide ample coverage of the novelty, including definitions for all key terms. Capture the technical aspects in the claim, not just a description of the result. You know, this is just all 101 today. It's like you cannot just say, you know, maybe 10 years ago, we tried to get as broad as possible claims. Remember those good old days? And we tried to put as little as possible in the claims. That's pretty much over. Now you have to put some technology, put some meat in the claim that allows you to get some patents. And again, not an abstract idea tied to a practical application. Now you go to the invention disclosure meeting and ask inventors to define the problem, get a description of the solution. I was telling you, make sure you get all the details of the pertinent ML parts. sometimes, especially in these areas, the data scientists are like, yeah, we create a model, and then we run this. Like, wait, tell me, what are the features again? You go that. What is the training set? Where does it come from? Sometimes things are obvious and they're obvious, and but you have to probe those data scientists. They tend to be very prone to underestimate what they've done. Again, technical solution, technical problem, and usually identify one practical application. In prosecution, I don't know, we had some questions. Anybody had a question? I see that it was kind of blinking. Oh, somebody put the machine learning for dummy download. Okay, great, thank you. All right. So some things that I found in prosecution is like, anything can be a model, right? Like you have your machine learning problem, and all of a sudden this guy tells you, oh, here's a fuzzy logic, or here's a decision tree. And man, again, when you get some cases that have been transferred to us and you don't have details to fight it, it's like, anyway, it's painful. Otherwise, you say, anyway, a human can do it with pen and paper. And then I can tell the examiner, there's no machine learning without a machine. It's not just data, it's not algorithm. You have to have a machine that analyzes the data, making inferences. So, and things tend to work out.
So Jose, a quick question on that. When you draft a claim, do you actually include the processor in the claim, or is it just all functional stuff?
I tend to be, well, I tend to add a processor. I mean, it's like in software. Typical thing in a system claim, you do your, or CRM claim, you put your processor, your memory, the instructions, and the instructions perform a certain set of functions. In the method, you tend to say at least, some of the operations of the methods or all are executed by a processor, because otherwise you get, this doing in the human mind. And I tell the examiners, like, yeah, you can do this in the human mind. It would take like 10,000 years. I mean, some of these things can be done in the human mind with pen and paper, but nobody could do it in a reasonable amount of time, right?
Yeah.
I have a question. I have a question on the model. So I've written a few of these, and I'm been looking at examples. But some of the examples I see on patented applications, and we're talking like 2019, 2020, not 2014. For a model, it just says a previously trained ANN model, for instance, like an automatic neural network.
Mm-hmm.
But yet, I don't know, that sounds kind of fluffy to me. What's your comment on that? Like if you just put that in a claim?
Okay. It depends. I mean, it depends. You have to look at the novelty, what you're trying to emphasize. Sometimes it's about getting the model. Sometimes it's about, I like to do like identify, okay, let's say a claim is like, training a machine learning model with a training set that includes these features, and then you start talking some specifics. Then you use the algorithm with a trained model. And then when the examiner is telling you that, oh, well, there's a model here, there's a model there, they say, well, the models are not the same thing. It doesn't have the same features, the same stuff. But sometimes, if your novelty is that maybe the models give you some parameter, but then you put it in a system and this is not where you're trying to focus your attention, then you can get away with that. If you're trying to say that the previously trained machine learning model is your novelty, but you don't say anything more about it, then in prosecution, you're going to have to amend and explain what it is the difference, because the examiner is going to give you a lot of previously trained machine learning models. So you have to show how your model train is different from the prior art, right? So anyway,
Okay.
that's at a high level.
Thank you.
Okay. Focus on the novelty. These are some of the things I'm telling you. Some interesting, there was some news recently that the PTAB is reversing 20% on A1 101 appeals for AI, so not a great success rate, but something. And in my current recent experience, I've seen fewer 101 rejections these days. There will be more allowances. I don't know, we are getting better at putting more technical details in the specs, or Mr. Yanku has changed the patent office where they have a better view. I know you don't quite agree with Mr. Yanku, but anyway, I think we have a different regime now than with the previous director. So that has helped a little bit. Okay, so here we have, okay, we have 15 minutes. Maybe I'll show you some of the cases that I've done without getting a little into detail. So this is it's called adversarial teacher-student learning for unsupervised domain adaptation. So this is very technical. Who was this? This was Microsoft. And, you know, it talks a little about, here you have two machine learning models. One is called the teacher and the model. And at a high level, the teacher is you train to do voice recognition on a noiseless environment. And then you have a student model that is trying to do voice recognition in a noisy environment. Of course, it's different. But now you're trying to use what you learn with the teacher model with the student model. So you can get better voice recognition in a noisy environment. So that's the basic idea. And it gets complicated, but anyway, basically it talks about one model relates to the other one. There's an adversarial conditions. Adversarial conditions sometimes happens when you're training different models, or you're training a model when you're trying to maximize or minimize two different conditions, but they conflict with each other. You know, either let's say you have accuracy or quality or something. So you're trying to get a balance. So those adversarial conditions are put into the model to get you to the right balance. You know? So this will get very, you know, this is about recognition. This will get technical about xenons and posteriors and priors. It talks about the relationship between the teacher and the student and the classifier condition loss. I won't get into all the details, but you can say it get technical. This is good. The examiner likes it. So we get an allowance without prosecution, right? So going through the claims quickly, but basically the highlighted part is you train the student model with adversarial teacher-student learning. Well, first, sorry, you train the teacher model. Then you train the student model with adversarial learning. And then you say the adversarial learning includes minimizing a teacher-student loss that measures divergence of outputs, minimizing a classifier condition loss with respect to the parameters, maximizing the condition loss, recognizing speech. I mean, this is an example. It's very technical. As you can see, this is a little bit about how you put math in plain English, and there's a lot of math concepts here. So I know we have the mathematical exception, but because you put it with a solution and a framework, you can get, I mean, you can get these kind of patterns a lot, even though they're very math related. Okay, another example. This is a checkout apparatus. This is a fun guy in a startup here in Palo Alto. Anyway, this is a checkout machine where you take your tray, you go through a cafeteria, you put your items on the train, you put it on their, you know, on the checkout counter. They have cameras all over the place. They do image recognition. They find out the items. They tell you how much they are, and they charge your credit account. So you put your tray, you wait a few seconds, and then you walk away. So it's a very interesting application. Now, one of the problems that they do is, like, you know, how do you recognize an apple? And to recognize an apple, you need a lot of pictures of an apple. So some of what they do is they pose the apple, different colors. You get a few images, but you still need many more. So what you do is you do some modifications. You change the color, change the hue, change the brightness, you know, hide part of the thing to get more images. And then with that, you get your training data. Then you get your kiosk on the field, and then you're getting images. By the way, these are 3D cameras. There's several 3D cameras. You're getting more transaction data. So that transaction data you can also use to improve your system, right? And this is my standard algorithm. As you can see, the features talks about image data, color, size, shape, position, transaction history, the geometry, the brightness, the user history, and others. So these are features that can help the machine learning model identify what you're buying. And you do the training, and then you do image recognition. So the claims, and this was allowed, it talks a little bit about, this is a little bit about getting the training data. You know, you capture images first, you repeat the capturing of the poses, and then I think you generate you generate additional color images, as I was telling you, then you build a machine learning model. But then you don't stop there. You also rebuild the machine learning model with transaction data. So as you get more data, then you can even start getting rid of all the data that you have to do, and then you can rebuild the system to improve it. Okay. Jonah, you want me to stop? I have 2 or 3 more cases. I can stop anywhere for any time for questions or.
Maybe this is a good point to let anybody
Okay.
who needs to go early ask some questions. I'm happy to stay later.
Okay, it won't take very long, but yeah, if anybody has some questions, yeah, go ahead.
I've got one, Jose. I'm just curious, going back to the inventor issue about recognizing AI as being an inventor. I think the court's got it right, saying that AI is not a person or whatever the language was. That makes sense to me. Do you have any predictions for whether that's going to change and AI could be an inventor in the future?
I thought a little bit about it, right? And I don't think in the near future is going to happen. But the question is like, the thing that I'm thinking about is like, okay, so I'm a smart guy and I do all these things and I come up with an invention. You know, how do I make an invention part of me? Like people use circuit development tools, to develop integrated circuits. This or software development to development software. So when people use the tools, they don't say, oh, you come up with a new program, the tool was the inventor. I mean, the question is to me is, how do you use the AI tool to come up with something? The question is, if I'm those guys in the UK, I come up with a new package container. What I'm thinking is, maybe as a businessman, is like, how am I gonna make that I am the inventor because I put all that together to make that happen? So I think there's a little bit of interesting development and how do you make people, be part of the invention. I think AI invention, anyway, I don't see it happening soon.
So Jose, there had been a comment in the chat window. Dan Smith mentioned that Holland & Hart uses a tool, and I guess it was an internally developed tool to take claims and prepare figures and specification.
Ah, okay.
Dan, I don't know if Dan works for Holland & Hart or just knows about that.
No, I work at Cable Labs, and Holland & Hart, they do some of our patent work, some of the AI patent work that we work on. I also know Mike Carey through NAP. We co-host the Colorado chapter of NAP at the Cable Labs offices. So he still has his tools, but I think Holland & Hart kind of took the initial tool that Mike Carey had developed and then brought in some PhD AI experts to work on that and some other aspects of Holland & Hart itself. So I think what they do is they draft a claim set, and then input that into the system, and it outputs specification, written description, and figures that they at least use as a starting point. They also use it for.
I've seen some tools do that, and I know I use Claim Master, and you give it a claim set, it gives you a figure, but. I mean, it's a valid point, but it doesn't give you that little extra. I mean, maybe you can get a claim set and you can put it there and you have it there, but when the extra is explaining all the terms, explaining all the definitions, there's much more than what's on the claims, and that's, the value of the patent attorney. So you can get away with something like that, but how do you prosecute? You get a rejection. If all you have is those claims that created the spec, then that's all you got. You get a rejection and that's it.
I totally agree. We have used them for some of our work, and I asked them to not use that tool because I don't think it really gets to what a draft person can provide. Yeah,
it could be a starting point. I mean, use tools as starting points. If you write the claim set and get that, but then you have to expand it. I mean, I usually my patent applications I have 1 or 2 figures of just background explaining the whole process, the situation, the problem. That to me is almost taking a good chunk of my time.
Yeah. I think they also use it for really quick provisional filings when they work with companies that are doing standards that they need something filed.
Okay, that works. Yeah.
I tried one of those tools too and had basically the same conclusion. I can see how it might save you a little bit of time putting together the boilerplate and the, a template for the application, but I don't see it saving 1 hour of time. And so it wouldn't be worth a lot of money at least to someone like me. I don't draft that many applications, so definitely isn't worth it to me. But for a law firm that would use it, I would think it would be a difficult decision about is it really worth much money.
Yeah.
I've inherited applications from auto-generated, and those are a disaster in prosecution.
Yeah, I bet. I see some of the values, some of the tools that are coming out today is like, you know, like, I don't know, whatever, but tunable pattern. I mean, that's a designing tool in which, you know, it kind of lets you start writing and then it keeps track of your figures and your numbers and your consistency of terms. So that is kind of assistance tool that is very valuable, but, you know, it still doesn't give you the meat. You put the meat and they help you with all those little things that are kind of, is like a routine, you know, you want to say, or quality assurance.
I have one other question, slightly different topic, but in the past, maybe 10, 20 years ago, people would try to patent something that's kind of obvious, but they would say, do it on a computer, and therefore they believe they should get a patent. And you know, the courts now say, you know, no, just saying do it on a computer doesn't make something patentable. Do you think in 10 or 20 years from now, just saying do it with a neural network, the courts are going to come and say, no, no, that's not patentable?
Yeah, well, no, I don't think it's in the future. I think that's today. I mean, if you come and say, I get a known data set and I get a known neural network and I put it together and you try to patent that, it's going to be a little tight. And I have some cases where it's been difficult. So that's why you have to look always for a little extra. You know, what is, are you adding a little technical concept? Are you helping with the training? Maybe, you know, in those cases, you don't have to start talking about vectorizing the data and put some details to at least differentiate with other stuff. But yeah, I think it's the same. Yeah, just using neural networks is not going to give you a patent.
So if anybody needs to drop off, I think we're roughly at 1 o'clock Pacific time right now. But Jose, if you want to finish the rest of your slides, or you have
okay, yeah, I'll think probably 5 minutes. I don't want to go. I think I have a couple more button applications. So let me share if you're interested.
I'm going to take off, Jose. Thank you. That's very interesting stuff.
Okay, thank you, Doug.
See you later. Bye,
okay,
bye guys.
See you later. Okay, so here we are. So again, this is a Microsoft patent, and basically, I mean, you have see the lady running here. This is about analyzing a bunch of messages for a user that doesn't have a keyboard, and then trying to assist the user via audio interface, right? So, so you know, let's say in this diagram, the user's request, okay, send me my message, or do I have anything urgent? And then, so the machine learning model or models analyzes the data to figure out, you know, get a summary or convert text to speech, analyze the content, respond communication. There's different options. Anyway, it's all for the user. But basically, let's say there's a message that comes to the user. So then you get a score for the sender. You know, maybe messages from your boss are higher priority than messages from Macy's, you know. So then you also get a score for action requests. If somebody wants something for you or a meeting, then you get a score, or an airline check-in request, etc. There's a bunch of scenarios in which you analyze. Each of those scenarios could be a model. So once you get all those scores, then you can calculate a message score based on that. So this just allows you to prioritize messages, and you know, you can set a threshold, and then this is important or not. Then you get generate the summary and send a verbal summary. So this is an assistant job. This is the kind of typical application. This can be a little difficult. Could be you're using the common stuff. It could be abstract, or this is what humans do for the beginning of time, right? But here's my standard diagram. Some of the features is the words in the message, some of the concepts, the communication history, the past behavior. You know, what do you do when you get a message from your boss, or when you get a message from this person? You know, who's the subject in the message? Some of the other attributes. The sender, I already said that. User data, etc. So you do put that, and you get your model or models. So here's the claim. So getting one or more messages from message sources, you know, being addressed to the user, you know, and then you talk about data that includes text. Here we focus on text. Then you analyze the message data to determine the meaning of the message. Okay, this is interpretation. Generating a score for each message, you know. Then you select the messages based on the score. Then you generate a textual summary for the selected message. Then you create a speech summary for the selected message. And then you send the speech summary to the user. So there's several steps. You put it all together, you get the score, you get the textual summary, the speech summary. Is the practical application. Again, this somebody is running, doesn't have a keyboard, so you can get some messages delivered via voice. All right. This is the problem. This is image recognition with unrepresented classes. And the problem here is when you're doing image recognition, imagine, you're trying to do image recognition, Google from the net. The algorithms like to have lots of samples, 1,000, 10,000 for each person. And then, you have your categories, person 1, person 2, person 3. But now let's say you have a guy, you only have 10 pictures. And then you don't have a lot of variety, but there's a different person. If you put those 10 data points with the rest of the other data points in the training set, it's gonna get lost. And this is called the unrepresented class. And then how can we promote it? And this is a little bit of the algorithm. And there's a math here and talks about one-shot learning with unrepresented class promotion. And basically what you do, and I have a diagram I'm going to show you, when you promote the few data points that you have, you promote for that user. And this is the math, kind of scary. I don't know if I would put the math in a diagram today after this was done a few years ago with the patentability exception. But anyway, so this is diagrams from the user. So here on the left, we have different colors for a well-balanced data set. Now on the right, you have a poorly class represented here, this .606. And let me see, what is the spotlight? Okay, here. No, oh, never mind. I was trying to get fancy. Okay, so anyway, so here's the 606 unrepresented. So what happens on the left, the chart before, when you do, remember how you divide the space into areas for data recognition? You have divided all the spaces, and then depends on where the data falls, that's our image recognition for one of those persons. And now, without the up term, so this is the left, without the promoting that term, that person's 606 is lost. But now with the promotion term, with the algorithms, what they do here, you promote this person. So at least there's a little sliver there, so you can find that person. And this was allowed without prosecution and talks about identifying a training set for the samples, dividing the training set into a base set and a novel set based on the number of samples in each class. Then you try one first classifier, and then you try the second classifier with promotion of the novel set. And the training of the second classifier, talks about minimizing a loss function, and that's the loss function that I have in the algorithm. And then once you have that training of the second classifier, you classify an item with the train second classifier. You can see it's useful. It's training that talks about the training, the things that you do with the training, the novelty, and you get your pattern. Okay. All right. That was it. I guess that's the last one. So,
can I ask just a couple quick questions?
Oh, of course.
First of all, thank you very much. This has been excellent. I noticed that every claim you've shown us is a method claim and not a system claim. Is there any reason why?
Well, my preference is for method claims. Let me see this. Well, okay, my system, when I do software, I do a method claim. The method claim is the most generic thing. I mean, it applies to software and systems, etc. And usually systems, we have a computer, the processor, unless somebody's coming up with new hardware or something, the system claim it doesn't do. I don't have other clients that produce hardware, and then maybe the system claim goes first. But in software, I do the method claims because it covers the method whether it's doing software or something else. And then I do the CRM claim and put the same embodiments for, within a CRM claim. But
okay.
I think the method is the most generic and broader.
Now, and then just my last question, just to follow on that, do you worry about what art group you're going to land in by focusing on the method claims?
Well, the art unit, you said,
Yeah.
I think, frankly, I don't play a lot that game. I know people do, and especially if you're always following the 3600 unit. I think the art unit game is done more of the abstract and the title, and well, also the claims. When you try to get that and get to a specific art unit, then yeah, I don't know if there's a method or not. It's going to make a difference. I think the important there is trying to take. Let's say you're going to try to get out 3600, any kind of business term, any kind of, anything related to people, you take out and then you start using generic terms and things like that. It's all about data and data processing and stuff like that. So
Right.
when you're trying to model that, and I mean, there's probably tools where you can get your application and run it by them and do RTNet predictor that you can get that. I don't do a lot of that, but I know other people pay more attention.
Thank you.